So you
Joy is found when we focus our energy on improving human dignity, human capacity, and human values. On this note, I, the Assistant Professor, Loyola College of Education, extends a hearty welcome to our Honorable Resource Person, Mr. Akhilesh Srivastava, Reverend Father Principal, Dr. P. Anthony Raj, SJ, Academic Coordinator, Dr. Monica Uppal, faculty members, and dear students. A very good afternoon to all present on this occasion to celebrate the International Human Rights Day. 10th December is an opportunity to reaffirm our importance to human rights, global solidarity, and shared humanity, especially during this pandemic. Now, moving ahead, I call in Dr. Shubhra Palit, Assistant Professor, LCE, to proceed further. Now, over to Shubhra ma'am.
I would just like to share that just because our resource person hasn't joined yet, I would like to request our Father Principal to kindly welcome the gathering and speak on the topic. Father, please.
Good afternoon. Wish you the very happy Human Rights Day today. To all on the platform, online, and those who are offline, I wish you all the happy Human Rights Day today. As internationally we observe Human Rights Day today because the human rights are at stake today. As you know, Human Rights Day we observe every year on 10th of December. Not only in India, but all other countries do observe this Human Rights Day on 10th of December. Why do we celebrate this Human Rights Day today and keep it as a set apart for the to look at human rights? Because Constitution has given the right, our Indian Constitution, and of course perhaps every country has its own constitution. The constitutions of each country has sanctioned the human rights to their citizens. And we can talk about human rights as long as there is a violation of the constitutional rights given to each individuals, individually and collectively. If any rights are violated by any group of people or any individual against individual or against the group, the human rights is talked about. And the human rights was given to us to protect and promote human life. We need to protect others, and also we have the responsibility to promote others in the way of exercising their rights. Can all exercise their rights? Yes, of course, everybody has the right to exercise their rights. But do all exercise rights in a practical, given situation? No. Because certain people rights are denied or deprived of or stripped of. So उसी संदर्भ में हम लोग का अपना जो हक है संविधान में दिया हुआ है, वो हक को हमको दिया हुआ है जब कभी हम लोग इसी देश का नागरिक होते हैं, वो ये हर एक नागरिक को यही हक है, फंडामेंटल बुनियादी हक, बुनियादी राइट्स भी है. कोई भी दल और कोई भी व्यक्ति उसको तोड़ने के लिए कोशिश करते हैं, तब वो हम लोग को राइट्स होता है. तो वो राइट्स को हम लोग का आज प्रकट करना है, उसको हम लोग एक्सरसाइज करना है. I can see the resource person on the screen, Advocate Akhilesh. He is coming on the screen. I will conclude, then he will take over. Okay, the human rights was to protect and promote human life. We have the right to equality, of freedom from discrimination. We have the right for liberty, personal security, freedom from slavery, and right and freedom from torture, degrading situation or treatment. So these are constitutionally guaranteed rights. And when we exercise the rights, when we start exercising our rights, or our rights are deprived of or taken off by a powerful group, then we fall prey to the victim's role. We fall prey as a victim. So as a victim or a person denied of rights, then we are empowered to struggle and fight for justice, fight for our rights. So today, the whole country is reeling under such a discriminative, such a situation where most of our people rights are denied. And our constitutional rights are at stake now. It's not only here. That's why you see across the world, you have seen the protests everywhere. Germany protest, Finland protest, US protest. All the countries are the people are with the human rights exercise activities. They are on protest because their rights are denied. So we have got today have a chance to come on the platform and listen to somebody who is really lived and witnessed and proclamating the individual right and community rights and stressing for constitutional rights to the government, to other oppressing forces. So we have Advocate Akhilesh with us. So now I will pass the mic on to the what you call the master of the ceremony, Mr. Subra, to introduce Advocate Akhilesh, and we will listen to you. Thank you.
Thank you, Father, for your enlightening words. Nelson Mandela has rightly said, to deny people their human rights is to challenge their very humanity. Human rights form the very basis of our freedom in a democracy. Human rights are not what someone gives us, but that which no one can take away from us. And today, we celebrate these rights and their importance in our lives. I, Mr. Shubhra Palit, Assistant Professor, Loyola College of Education, am privileged to introduce our Honorable Speaker for the day, Mr. Akhilesh Kumar Srivastava, Advocate, Calcutta High Court. Our respected speaker for the day is a practicing advocate in the Honorable Supreme Court, High Courts, and Tribunals. Elaborating on his professional qualification in finance and law, he holds an FCS from the Institute of Company Secretaries of India. He also holds an LLB from Ranchi University and BSc Chemistry Honours from Ranchi University, Ranchi, Jharkhand. Our Honorable Speaker is also a fellow member of Institute of Cost and Works Accounts of India, having passed his FCMA final examination in December 1995. Mr. Nishant Akhilesh has been a part of People's Union for Civil Liberties for the last 35 years. LCE family welcomes you, sir. We are privileged to have you amongst us today. Now, I would like to request our Honorable Resource Person, Mr. Akhilesh Srivastava, to kindly carry on with the day's proceedings. Welcome you, sir. Over to Mr. Akhilesh Srivastava.
Thank you so much, ma'am. And thanks, Father. And I sincerely, very sincerely apologize to be late by at least 10 minutes because we had a program at it still continuing. I had to rush back and join this very important meeting of today. So without wasting any further time, may I be allowed to start small submission of mine on this August day. Friends, for India, we secured our freedom on 15th of August 1947. That was freedom from English people, freedom from English Raj, and then we were in a position to elect our own kind of government of our own liking by electing MPs and MLAs for the center as well as the states. But the actual freedom for the teeming millions of this country was achieved on 26th of January 1950, when we adopted our constitution and conferred to ourselves the fundamental rights and fundamental freedom as enshrined in part 3 of our constitution. So what is human rights and why do we celebrate 10th December as a human rights day? These two things are very, very important, and a little bit of genesis of it. As I said, that we achieved our political freedom on 15th of August 1947. The people of India achieved its political, economic, social, and cultural freedom on 26th January 1950. Similarly, the people of this entire world achieved their freedom, achieved their basic rights on this day, that is 10th of December 1948, when United Nations, after a devastating experience during the Second World War, when lakhs of people got killed, the whole world had to think, assemble together, fathom, and then they came out with a solution. And then they prepared a charter called Universal Declaration of Human Rights, which was adopted on this very particular day. Now, what does it signify? But before I come to this, I'd like to give you a small account of how the journey towards human rights started. So I go back to 400 years back from Christ, Jesus Christ. When Sophocles advocated natural rights, we all witnessed throughout the journey of the human history the man-made laws. We have seen tyrant despots. We have seen and witnessed benevolent despots. But we found, the people of this world, found man-made laws as inadequate. So there was need, there was demand to recognize something which is superior than man-made laws. And that was natural rights. And that was first advocated by Sophocles 400 years before Christ. So mind it. The quest for a superior order in which the fundamental rights and fundamental freedoms of people are protected, it started 400 years back, Jesus Christ. Then in 1700, Blackstone of England advocated natural rights. So I can safely say that fundamental rights have originated from the natural rights. When we are born in a natural environment, we are not bound by anything. We are completely free. If you are groomed in a complete free environment, we will be completely free of any religion, any caste, any prejudices, anything. We may not have a language. We may not have anything more, many other things. But we will have our natural freedom under an environment of natural rights. So I'm just taking piecemeal examples because I have to conclude this session Otherwise, I have taken you about the history of genesis of natural rights first, and then to the political rights, then fundamental rights, then human rights. All these terminologies are normally used interchangeably, but they are not the same. There are subtle difference between them. So, in order to achieve a superior order in the form of natural rights, we first needed a political journey which we started 400 years before Jesus Christ. And even by 1700, Blackstone had to advocate it in England. I'll just take a break. I beg your pardon. I just take a minute to explain to you that each human rights has its origin in England. I don't know how many of you know this. And England does not have any constitution. There is no constitutional guarantee of human rights in England. I'll come back to this issue again later. First, see the situation. We started our journey 400 years before Jesus Christ, but by 1700, Blackstone, a champion of human rights, had to advocate the acceptance of natural rights as a superior order than the man-made laws. Then two things. Another one thing that really helped shaping up the development of human rights. As I said, our human rights originated in the natural rights, but natural rights were only a nebulous concept. There was no recognition, political recognition. There was no mechanism to implement that, to make those rights available to the millions of people of this world. So we needed something more to happen in that course. And what was that happening? What was that historical intervention for recognition or transformation of natural rights towards or into human rights or fundamental rights? That happened because of international law. Now, if I go back to 1650 again, one Dutch philosopher, Grotius, he propounded, that was the time when international law only recognized states, their sovereignty, their freedom, their liberty, not the liberty of individuals. At that time, Grotius, that great Dutch philosopher, he opined that if a sovereign state continues trampling upon the human rights of its subjects, it doesn't remain a domestic issue. It doesn't remain an issue within the sovereign powers or within the liberties of a state. It becomes an international issue. So if the subjects of a particular country are facing violation of fundamental rights, violation of their fundamental freedoms by its state, then it becomes an international question, and the neighboring countries and the countries of the world, they develop the right, assume the right to intervene. They may not affect the sovereignty of that state. They may not affect the freedom of that state, but they will definitely intervene to ensure that fundamental rights of the people of that particular country, subjects of that country, are not violated by its state. So now, before proceeding further, let's come to the definition. Then what is fundamental right? What are human rights? Human rights are then essentially an embodiment of fundamental rights and fundamental freedoms, which are available versus its own state. I think you got it right. We have our fundamental rights and fundamental freedoms versus, that means against, our own state. Why do we define the human rights like this? The reason is, after that intervention of international law, it was felt the need to codify human rights. Because after that devastating experience of Second World War, the countries of the world assembled together and they realized the need to recognize individual as part of international law, and not only states, not only two sovereign countries. So international law's intervention and its progress came to a place where it had to recognize the rights of individuals, rights of individual people, rights of a citizen of this world, not just one country. And that paved the way to codify this law. And that codification came by the adoption of a charter called Universal Declaration of Human Rights. You must have heard, most of you must have heard this at least, if not other things. So Universal Declaration of Human Rights was adopted on this date, 10th of December in 1948 by the General Assembly of the UN, United Nations. And it was initially signed by 35, then by 81, it was signed by almost 70 countries of this world. And today, there are majority of states, majority of countries who have signed not only this pledge of human rights before the UN, but they have also signed two important covenants that was enacted in 1966 by the same General Assembly of UN, that is Covenant on Civil and Political Rights, and another covenant on economic, social, and cultural rights. In 1966, these two covenants were adopted by the UN, and India also made a signatory to in 1979, if I remember it correctly. Then what does it signify? If you see the time, 10th December 1948, this Charter of Human Fundamental Rights and Fundamental Freedoms were adopted by UN, and at the same time, India was deliberating in its Constituent Assembly for formation of its own constitution. Constitution was based on Government of India Act 1935, but Bill of Rights, that is Part 3, Fundamental Rights, were borrowed from the Bill of Rights of 1791 of US Constitution, and also this Universal Declaration of Human Rights. Not in toto, but substantially. And that was made part of our Constitution. Now I'll discuss a comparison between two countries to give you an idea about this constitutional guarantee of human rights and where we do not have a constitutional guarantees. Absolutely two contrasting countries, and you will be surprised by the end result. We have a constitution in India which guarantees our fundamental rights and fundamental freedoms, starting from Article 13 to Article 32. As you all know, Article 13 is very important because a lot of deliberation was made in our Constituent Assembly to adopt this Article 13, which says that state cannot enact a law or by any administrative means to violate the fundamental rights and fundamental freedoms of the subject. So any enactment, any law, or any action by the executive, to the extent it violates the fundamental rights and fundamental freedoms, are null and void ab initio. That means if a law is enacted by central government or by any state government in India, violating your fundamental rights and fundamental freedoms as enshrined in our Part 3, it is going to be declared by the court under Article 32, by the Supreme Court under Article 226, by any of the high courts as null and void because it violates your fundamental rights and fundamental freedoms. Now, contrastingly, if you go to England, where I have just said that the origin of each of the human rights, you will find only in England. Because in England, not only the law developed through their tradition, but each of the human rights of this world today, which are existing today in any of the constitutions of this world or in any other law for that matter, because there are countries where no constitutional guarantee of human rights, but only legal guarantees of human rights, like USSR, even England. So there is these rights originated, all fundamental rights, all human rights originated in England, but England does not have a constitutional guarantee. There is no constitution, in fact, in England. So there is no constitutional guarantee. That means if a law is enacted by the Parliament of England, which violates your fundamental rights and fundamental freedoms, the Supreme Court of England is not going to declare it unconstitutional, violative of your fundamental rights and fundamental freedoms, because there is no constitution. But you will be very surprised. Not surprised, you may be knowing it, and you should know. If you do not know, you must know that there are very, very limited violation of human rights in England. Why? Because the human rights developed through their tradition. Their common law, their judges, their lawyers, their citizens, their administrators, they all respect human rights, which have developed through their development of their civilization. So there are very limited violation of fundamental rights, fundamental freedoms, despite there being no constitutional underpinning of these fundamental rights and fundamental freedoms in England. But in contrast, we have a constitution which guarantees our fundamental rights and fundamental freedoms. But you will find after China, India has the highest number of violation of human rights. It's seriously contrasting. A country having no constitution have minimum limited violation of human rights. A country having a constitution guaranteeing our fundamental rights and freedoms has highest number of human rights violation in the world, after probably China. Because it is now very difficult to compare China, the violation of human rights in China and India. It has come at par, probably. Then what was the role of, when we adopted our constitution and we already provided constitutional guarantee of our fundamental rights and fundamental freedoms, then what was the role of UN? The role of UN was still very, very important. Because the signatory, I beg your pardon, UN, by directing its subject states to sign the treaty, it obligated them to implement the Universal Declaration of Human Rights by enacting laws in their country or by giving effect into their constitutions. That was an obligation. Now, this obligation has also some technicalities. I'll take one. Because international treaties are essentially between two governments. So if I again invoke England, these international treaties are signed by their executive. And the executive cannot, if something is signed by executive, then it is not a self-executing law. So even if England has signed the Universal Declaration of Human Rights and two covenants of 1966, they are not self-executing law in their municipal law, that is in the municipal law of England. So Parliament of England has to give effect to those fundamental rights and freedoms which are there in the Universal Declaration of Human Rights and the covenants, but they are not there in the municipal law or common law of England, by enacting a law. But if you go to USA, the Constitution of USA, Article Roman 6, it says that international treaties executed by this country are the supreme laws of this country. That means the international treaties, especially this Universal Declaration of Human Rights and the Covenants of 1966, are treated at par with their constitution, and as such, the courts in USA, when they examine the violation of human rights, they not only invoke the constitutional protection conferred in their constitution, but they also invoke the fundamental rights which are enshrined in these Universal Declaration of Human Rights. So you can understand the difference, because for USA, an international treaty is a self-executing law. Now come to India, we do not have an article like this. So even if we are signatories to the Universal Declaration of Human Rights and the covenants of 1962, covenants of 1966, it is not a self-executing law in India, and then we are expected to enact laws to conform to the international guidelines set up by the United Nations. However, fortunately, our Supreme Court has opined that if you are the signatories to those covenants, and if you are part of the UN, then we are bound to conform to that. And it presupposes the application of those principles enunciated in the United Nations of Universal Declaration of Human Rights and those two covenants, civil and political rights and economic, cultural and freedom, cultural and social rights that are contained in that covenant of 1966. So fortunately, despite the international treaties are not self-executing law, as per our constitution in India, Supreme Court has very liberally, but it has happened long back. For the last 10, 20 years, Supreme Court has not passed any such, I would say, benevolent law, which is in favor of people of India. That is an unfortunate development of Supreme Court, functioning of the Supreme Court in last 18, 20 years. Now, before I conclude, I think I have given you a little idea about the human rights and why they are called human rights, are called fundamental rights in India, in other parts of this world, because these human rights are recognized in our constitution, and constitution provides a limitation on the legislature not to violate your fundamental rights or fundamental freedoms by enacting a law or by any administrative action. That's why it is constitution is the fundamental law of the land, and if constitution is underpinning your fundamental rights and fundamental freedoms, then it becomes your fundamental rights. So in England, these are human rights. In India, these are fundamental rights. In USA, these are fundamental rights. In many countries, these are fundamental rights. In some countries, still like USSR, these are only legal rights. So these are the terms used interchangeably, but they are not. They are different. You must understand that fundamental rights are different than human rights. Human rights are different than your civil and political rights. Civil and political rights are different than legal rights. So all these terms, though in the context of human rights, are used interchangeably, but they're not the same, because they are standing on different echelons of constitutional guarantees or legal guarantees, for that matter, across this country. Now, before concluding, I come back to this point that after we adopted our constitution on 26th January 1950, our rulers, there was transfer of power, as you all know. There was no election in 1950. There was no election in 1947. It was only transfer of power from English to your Congress party. Congress party was not very comfortable with the fundamental rights. Many things happened. Immediately after the adoption of our constitution, that's why I call that we secured our freedom on 26th of January 1950, and the estate, as usual, started violating our fundamental rights from the word go. The first case I would like to share with you, 2-3 cases. In May 1949, before we adopted our constitution on 26 January 1950, 20 communists were arrested under Bombay Safety Act at Bombay by the Commissioner of Police. And they remained in jail for 8 months without trial. After the adoption of the constitution, they went to the Bombay High Court, stating that their incarceration without trial was wrong. It was inconsistent with the fundamental rights and fundamental freedoms enshrined in our constitution, which we adopted on 26th of January 1950. The Bombay High Court on 8th of February, released them. It declared their incarceration as invalid. But the mindset of the rulers of this country had not changed. They were not ready to allow you, even though they placed it. If I recall Mahatma Gandhi, that was during the second Golmej Sammelan, we call it, roundtable conference at England. Mahatma Gandhi pronounced that after independence, we shall form a political organization in which there will be no distinction between high class and low class. Women will have same rights as men, and dignity and justice, economic, social, and political, would be ensured to the teeming millions of this country. These are probably the exact words of Mahatma Gandhi stated during the second roundtable conference in England. And if you can just correlate with your constitution, that formed the basis of your preamble. It is written just behind me. That formed the basis of the preamble. That formed the basis of our constitution. But rulers were not ready to allow your fundamental rights and fundamental freedoms. Immediately after that Bombay High Court judgment, 200 communists which were incarcerated at Salem jail at Tamil Nadu, they revolted. They sat on dharna and they demanded that they should have been treated as a political prisoners, and they should not have been forced to stay with the hardened criminals, convicted criminals, and wear black clothes that were designed for those criminals. It was a revolt, but it was not a very violent revolt. But then police came and as usual tried to contain them, and there was a fracas and some policemen got injured. Then what happened? You see, on 26th of December, sorry, I beg your pardon, on 26th of January, we adopted our constitution. And on 11th of February, what is happening at Salem jail? All these 200 communists were taken to a hall, locked down over there, and they were fired on by the police, killing 22 communists on the spot, injuring 117. So out of 200, 117 got injured and 22 were killed. Then there were many developments. A communist-leaning newspaper was banned because it was criticizing Congress. Organizer, which is a right-leaning, obviously, of that communist newspaper, was owned by Ramesh Thapar, brother of Romila Thapar. It was probably Crossworld or Crossroad, I beg your pardon. Then Organizer was also banned, and both the matter went to Supreme Court, and Supreme Court declared those the government action as illegal. Such was the situation. Government was so terrified by the interpretation of their own constitution adopted by them only, by Nehru, by Patel, by others. They were so terrified that they started talking nonsense against Indian constitution. Congress of Bihar openly stated to scrap the constitution and implement the social agenda of Congress. Our own Prime Minister stated publicly that if you have to you have to choose between security of the state and the fundamental rights and fundamental freedoms, you should choose security of the state. Now, security of the state was all of a sudden, we got our independence on 15th of August 1947, adopted our constitution on 26th January 1950, and immediately in 1950, the security of a state was a big problem. What was the threat against the security of our state? English people had gone by that time, and we are under our own ruler. But security of a state was falsely made an issue. late Jayaprakash Narayan, who founded this organization, People's Union for Civil Liberties, he used mockingly a word, Sankatwad, to criticize the central government. Our Home Minister, Patel, in a public meeting, he stated that adoption of fundamental rights was probably an idealistic exuberance. That was completely utter nonsense. And that reflected complete lack of respect for for their own constitution adopted by themselves just few months back, 2 months, 3 months back. And in February 20, in February 50, I beg your pardon. In 1 month, that is, it probably happened on 26th of February, India adopted a preventive detention law in contrast to our Article 22. Then we amended the constitution. I am not going into details of what happened thereafter. A lot of things happened. And then finally, our constitutional, the first amendment of constitution got affected by the parliament. 228 people supported that. Rest of them boycotted because they had respect of their leaders. They had respect of the government. However, most of them were completely against it. But the first amendment was a big blot in the constitutional history of India because it happened within few months from the adoption of the constitution. And by the adoption of that, two things, very important two things happened in 1951. One, our fundamental freedoms were curtailed further. Our fundamental freedoms were already subject to certain things like libel, slander, contempt of court, security of state. These words were already there. But by this amendment, they also added a public order. Now, the same public safety acts which were declared unconstitutional by different high courts, those public safety acts, they were acts. They were not part of the constitution. But you see, by this amendment, that concept of public safety act was incorporated in your constitution in the form of public order. That means your freedom of speech, fundamental freedoms can be curtailed in the name of public order. Now, what is public order? It is undefined in the constitution. Even after 70 years of adoption of our constitution, it remains undefined. That helps the state. And one more thing, with this I conclude this part. One more thing happened, that the Congress government reintroduced the sedition. At present, you are listening so many things. Anti-national word is now so common. So this was also common in 1951, in 1950 and 51, when the first constitution amendment was carried through. For the last 5 years, we have been listening this every now and then. You do anything, you criticize the government, you are called an anti-national. Immediately, you are an anti-national. You go to Pakistan, you do this, you do that. Or if you criticize more, you will be booked under UAPA. Like our father stand was taken. Sudha Bhardwaj has been taken under UAPA. UAPA is the most draconian law of country today. Because you don't get bail from the court. Even though provisions are there, but if you are taken in under UAPA on flimsy grounds, frivolous grounds, your bail is not going to be granted by any court. We have seen the issue of Father Stan, the way he has been taken. Criminal law is essentially in the domain of the state. But UAPA is a law enacted by the central government without any provision in our constitution. And under that provision, a police is coming from Delhi, apprehending Dr. Stan Swami, claiming an anti-national, doing something against the state which we never heard in 50 years of his life, taking to Bombay without the permission of our state government, seriously violating not only his fundamental rights and fundamental freedoms, also violating the federalism, which is another right conferred to the state. So sedition law was reenacted by Nehru and others. by the First Amendment, giving retrospective effect. At that time also, they found those criticizing as anti-nationals in 1950. But my friends, I would like to bring a few words of caution, few words of wisdom, the difference that we are witnessing today from 2014. From 1950 to 2013, we have seen several amendments curtailing our fundamental rights and fundamental freedoms. So many. Call me on some other occasion for 2-3 hours. I'll be deliberating on some of the serious amendments of the Constitution curtailing our fundamental rights and fundamental freedoms some other day. But today, I limit myself by saying this, that till 2013, we faced an attack on our fundamental rights and fundamental freedoms, I would say political rights, by all the governments that ruled us after the adoption of our Constitution on 26th January 1950. But this government from 2014, which has come to power, is not only ready to coup the grass. That means they are ready to give the vital blow to your, not only to your fundamental rights, that is political rights, they are systematically dismantling your economic, social, and cultural rights. Mind you, the biggest threat today is to the minority rights, which are contained in Article 25 to 29. Your right to set up a school, your right to set up a business, your right to propagate your religious tenets, beliefs, these are seriously under threat. They are the backbone of our Constitution. These were never under threat to this extent, at least I would say. Our political rights, fundamental rights and fundamental freedoms have been under attack of our own governments all these years up to 2013 and 14. But from 2014, there is a government which is not only ready to give final blow to our political rights, but it is systematically dismantling our economic rights, our social rights. Reservation is under threat. Our livelihood is under threat. What is your opinion about that demonetization? It was not for the elimination of your money, counterfeit notes, or black money from the system. Because earlier black money was supposed to be brought by BJP from Swiss banks. All our black money are supposed to be parked or deposited in Swiss banks. That was the slogan, political slogan. But then he did not bring one single penny from Swiss bank, enacted demonetization. Was it any economical measure? Was it any action to eliminate black money, eliminate counterfeit notes from the system? No, my friends. That was a systematic attack on your fundamental freedom. Because by that action, the government was able to take into control the RBI's independence. And you must be knowing that RBI had to surrender its 1.76 lakh crores of rupees to the government, which was its reserve fund. So today, Reserve Bank has no option. It doesn't have money. It has no option but to print new notes if the economy has to be sustained or economy has to be carried on from here. Economy is already into sink, in pits. And 14 crore people have been unemployed. And in 5 years, what the economists of this world have estimated that we shall not be able to probably re-employ these 14 crores. Forget about another 5 to 10 crores youths. At present, around 5 to 6 crores, which are unemployed. In another 5 years, we will add around 4 to 5 crores. So it will be around 11 crores youths which will be unemployed after 5 years. With these 14, it comes to a staggering 25 crores of people. Thereafter, everything that they have done, that is abolition of wealth tax. How many of you know this? I think none of you may be knowing this abolition of this wealth tax and the impact of it. Wealth tax is gone immediately after the coming into power of this government. And then they enacted an IBC, Insolvency and Bankruptcy Code in 2016. Under this, they allowed all big corporate, Tatas, Ambanis, Adanis, to misappropriate the wealth of the nation. They have already misappropriated. They have, in 70 years of operation of our economy, in violation of Article 39B and C, they have already misappropriated substantial wealth of this country. But in 4 years, they have amassed like anything. I was just reading a newspaper today in the Prabhat cover. You may be knowing there is a dispute in Tata Sons, between Saporji Palanji Group and the Tatas. Saporji Palanji Group is holding around 18.37%. You can see my tweets of today. 18.37% of shares in Tata Sons. They stated in the court yesterday, before the Supreme Court, that the value of their 18.37% shares in market in 2016 was merely 58,000 crores, I beg your pardon. Today, the value is 1.75